Good evening, ladies and gentlemen. Tonight, we will have the 8th session for the bar review for the University of the Visayas Golias Law School Operation Bar Excellence. And tonight, we will take up a very important aspect of labor law, which is the visitorial power of the Secretary of Labor and the inspection, as well as the issuance of compliance order and rates of execution. To give you a review of our schedule, today is the 20th of July. We have session number 8, and our topic has been predetermined. This is Article 128, as well as Article 37 and 289. These are the three visitorial powers of the Secretary of Labor. If you are asked in the bar examination, what are the three visitorial powers of the Secretary of Employment under the Labor Code of the Philippines, your answer will be the following are the visitorial powers of the Secretary of Labor. Number 1, Article 37, which pertains to recruitment agencies. The Secretary of Labor or his duly authorized representative, upon their own initiative, without the need for any complaint, can go to any recruitment agencies, examine the documents, interview the employees, and gather facts that may serve as basis for an order coming from POAA, coming from the Office of the Secretary, or coming from the Regional Office of the Department of Labor that may affect the license of the recruitment agency if there are serious violations like illegal recruitment or commission of prohibited acts under Article 13, Paragraph B, Article 34, and Article 38 of Book 1 of the Labor Code of the Philippines. The second visitorial power, which will be discussed tonight, is Article 128, which is the biggest of all the three powers, because it covers all kinds of establishments, and the word establishment means any commercial unit, whether or industrial unit or agricultural unit, any company, whether a medium scale, large scale, small scale, or micro enterprises, as long as there is one employee. Establishment can be visited by the regional director or the inspectors from the regional office, and they are authorized by law, by explicit provision of this law, to examine the payroll, to look at financial documents, to interview the workers, to go around the establishment and determine whether there is compliance with labor standards, as well as occupational safety and health protocols. And the third visitorial power is Article 289, which is about labor unions. And the only time that the Secretary of Labor can go and inspect or his duly authorized representative is when there is a petition coming from the members of the unions to audit the books of account whether or not the union funds are used by the union officials in accordance with the constitution and bylaws, and whether or not there are malversation of union funds or diverting union funds for purposes other than what is intended. And so let us now start to examine the provision. Before we go further, I encourage you to have a copy of this book, because this book now is a very hot item. All the universities in the whole countries are lining up to buy a copy of this book, because not only this is about 1,000 pages and very systematically arranged, and it is based on the syllabus issued by the Supreme Court Associate Justice Marvick Leonen, the chairman of the bar examination 2021. And this book has strategy and tactics and techniques in review, as well as many mnemonic devices in order to make it easy for you to memorize and to understand. So this is for bar review. For pre-week, we also have pre-week, and we even have 88 hours before the bar examination. So better for you to get a copy of that. So this is a very hot topic about the three visitorial powers of the Secretary of Labor. And the Secretary of Labor, as you can see, is one of the most powerful officials of government because of the tremendous delegated authority by law. Remember that the Labor Code of the Philippines was promulgated during martial law, and the most prominent among the three branches is the executive at that time, because legislative was abolished, and the Supreme Court was quite respectful of the powers of the executive, which were exercised by the President of the Philippines in his capacity as the Commander-in-Chief of the Armed Forces by virtue of Proclamation 1081. And the President has delegated a lot of these powers to the Secretary of Labor. One of our session, I will go one by one and discuss these powers. But today, the power that will be discussed is visitorial power. What is the nature of a visitorial power? A visitorial power is a form of quasi-judicial, quasi-prosecutorial, and it is also executive and administrative. Because without the need of a hearing, an order may be issued as based on the report of the inspector. So let us now examine the provision of Article 128 very carefully, line by line. The Secretary of Labor or his duly authorized representatives, that includes the inspector, officially called the Labor Regulation Officer, shall have access, remember the word shall have access to employers' records and premises. So it is illegal to prevent the inspector from entering the premises of the company. That will be considered obstruction. And that is, their entry is any time of the day or the night. They can even enter at night. Can you imagine this power? The government can enter the premises of a private company even at night, provided that there is operation, like San Miguel Corporation, 24 hours bottling of beer. Since there is an operation in San Miguel for 24 hours, then the Dole can go to San Miguel even at night, because the only requirement is whenever work is being undertaken. And since there is work that is being undertaken at night, therefore the inspector can come and have access to employers' records and premises. And they have the right to copy from these records. They can copy, they can take picture, and they can question any employee around, whether the employee is a managerial employee or a union member, supervisor. It does not matter. The inspector has the right to ask questions and investigate any fact, condition, or matter. For instance, if there is a machine that to the mind of the inspector poses a grave or imminent danger to the life or security of the employee, the inspector can investigate, can scrutinize, can evaluate, can assess, can interrogate in order to determine whether there is violation. So they are really looking for violations. The inspector is a licensed fault finder. Licensed fault finder. It is a licensed detector of violation. And anything that, any condition that has something to do with the enforcement of the labor code or any other labor law, not just the labor code. There are many other laws that, labor laws that are not in the labor code. For instance, the law on solo parents law, violence against women and children law, the law on against the hiring of minors, the Magna Carta for women, the Magna Carta for children, the Magna Carta for PWD, insofar as they relate to working conditions. They can also be subject of the inspection. And the second paragraph says that even if there is an Article 129 and 217, which is now 224, this inspection will go on nonetheless. So what is Article 229? It is about simple money claims. Simple money claims when the workers will go to the regional office and file a claim. So later on we will make a distinction between Article 128 and 129. Because 128, it is the government, it is the dole that goes into the company. While 129, it is the complainant that will go to the Department of Labor. That is the difference, no? So, even if there is an Article 129, if the money claims is uh, 5,000 pesos or below per complainant. And the moment it exceeds 5,000, it will go to Article 224, which used to be Article 217, and that is the NLRC, the labor arbiter. So even if this exists, the visitorial power will still continue, and the secretary shall have the power to, or the regional director shall have the power to issue compliance order. So what is a compliance order? If you are asked, what is a compliance order? The answer is, it is a written directive coming from the regional director by authority of the Secretary of Labor under Article 128, and this order is addressed to the establishment, to the management of the company. And the contents of this order are list of violations, like violation in the payment of overtime pay, underpayment in minimum wage, or non-payment of holiday pay, all labor standards. That is one classification. The other classification is occupational safety and health. No personal protective equipment. There is a violation on the use of machine. There are obnoxious chemicals emitting poison, and the employees are in serious danger of some infection on their lungs. And especially today with the COVID crisis, the Department of Labor is very active in enforcing the protocols to avoid the contagious infection in the workplace. So, a compliance order, therefore, being an order, must be complied with. Once the management receives this order, it has two options. One option is to comply and file a manifestation of compliance. And second option is to appeal. To appeal to the office of the Secretary within 10 calendar days. What are the grounds for the appeal? The same grounds for appealing a decision of the labor arbiter to the NLRC. The same period of 10 calendar days. And what are these grounds? Grave abuse of discretion, serious errors in the findings of facts, which, if not corrected, will cause grave and irreparable damage to the company. Company. 3 is question of law, pure question of law, and 4 is corruption or graft. So, an order, therefore, is very effective mechanism to implement the constitutional mandate to afford full protection to labor. And the third paragraph says that if there is no appeal and 10 days have lapsed, the regional director can issue a writ of execution to the sheriff or the enforcement of this compliance order. Except only when there is a question. And this question can only be done through an appeal. And this is a question about issues that are not verifiable in the ordinary course of inspection. Example, the question of law. Because the compliance order may include a directive upon the principal employer to absorb the employees of the contractor on the premise that the contractor is a labor-only contractor. So that is a question of law, because if you make a conclusion that an agency is a labor-only contractor, you are interpreting Article 106 of the Labor Code of the Philippines, and interpreting 106 involves a question of law, and therefore that can be raised as a ground for appeal. No? So if there is a question raised, the order cannot be enforced by a writ, because there is a valid appeal, and this appeal can be valid only if there is a ban. If the inspection report gives computation of the amount that should be paid by the employer, and now it is required that it should include a computation, therefore that amount stated in the compliance order should be covered by an appropriate cash bond or a bond issued by a duly accredited bonding company. And the purpose of that bond is to make sure that there is money in case the decision of the regional director, the compliance order, in case that is affirmed by the Secretary of Labor and becomes final and executory. This filing of bond, you might be interested to know, was not in the original provision of the Labor Code. This was only inserted by Senator Boy Herrera from Cebu when he authored Republic Act 6715 amending the Labor Code, and that was in 1989 after the EDSA Revolution of 1986. Boy Herrera became a senator, and he authored the amendment, and he introduced this amendment because of a very sad experience in the past that workers win their case. After 10 years of fighting, they win their case, and after winning, there is no money to pay, because the employer has already transferred all the money to another company. So by maneuvering, it becomes an empty victory. Imagine you win your case and there is no money to pay. And so now Senator Boy Herrera makes sure that when there is an order that has become executory, the workers win, there is money reserved, either in cash to be deposited in the cashier of the Department of Labor, or a bond, and this bond will be paid by the bonding company, just like the bond in a criminal case. You know, Boy Herrera has made a lot of very good laws for the for the welfare of the workers. Another law that he passed was about the absolute preference. In Article 110 of the Labor Code in Book 3, when the employer becomes bankrupt and the assets are not enough, before, in the original version of the Labor Code, the first preference goes to the government to pay taxes. But because of the amendment introduced by Senator Herrera, the first preference now are the workers. Even before the taxes of government are paid, the salaries and benefits as well as separation pay of the workers must first be paid. If there are no more money after paying the workers, then the posting of a cash or surety bond will is considered as essential, and without this bond or this cash or surety bond, the appeal is not considered filed. And so if the appeal is not considered filed, then the decision or the compliance order becomes final and executory. Okay? And then this is the most dangerous power of the regional director. The third paragraph. He can order a stoppage of work. You know, about 2 years ago, my friend in Pepsi Cola, Cebu, called me and said, "Sir, help us because the regional director issued an order to stop the operation of Pepsi Cola plant in Minglanilla." Why? Because somebody died. Somebody died because of an accident involving a machine. Well, that is the power of the regional director, delegated by the Secretary of Labor. And there is no need of a prior hearing before issuing that WSO. When you hear the word WSO, that is work stoppage order. The hearing will come after the issuance of the order. Order first before hearing, because the urgency is justified by the fact that what is involved here is life, the life of the workers. And so, when there is anything that poses grave and imminent danger to the health and safety of the workers, the Secretary of Labor, through the regional director, may issue a WSO. And within 24 hours, a hearing shall be conducted. So, na-issue muna yung WSO, then the hearing will follow after within 24 hours from the issuance. And the purpose of the hearing is to determine whether the danger has already been removed, whether the error has been rectified, and the safety and health of the workers are now sufficiently safeguarded. Absent any substantial evidence that such a situation has been addressed, the work stoppage order can continue. And there is no deadline. Even if it will last 1 month, if management continues to fail rectifying, the provision of the law is silent as to until when. The answer is until the danger is removed, because the removal of the danger is in the hands of the company. So, you see, gentlemen and ladies, how the state, pursuant to the provision of Article 13, Section 3, to afford full protection to labor. And this is a very strong manifestation of protection to labor, because what is involved here is the life and security, the health of the employees. And if there is a work stoppage order, the question now is this. So, if there is no work, are the workers going to receive their salary because there is a principle of no work, no pay? The answer is no. They will continue to receive their pay, because it is stated in case the violation is attributable to the fault of the employer. Siyempre naman, sino pa ang magiging at fault na noon, no? The employer shall pay the employees their salaries and wages during the period of such stoppage or suspension of operation. So, if you are looking for an exception to the principle of no work, no pay, this is one exception, where even if there is no work, since the absence of work is not the fault of the worker, it is the failure of the employer to address the situation discovered by Dole, then the employer should pay wages and benefits. Now, the issuance of writ of execution. So, the writ is addressed to the sheriff. The sheriff is ordered to go to the company and to enforce the order. If the order says pays 1 million pesos, the sheriff will now go and say, okay, here's an order, you pay. If you have no money, I will go to the bank to garnish. And you know what is the meaning of garnishment. The sheriff will issue a letter to the bank manager that all the account of the company should not be touched. If the company issued a check against the account, that check will not be honored by the bank, because there is a garnishment order. And the bank has no right to question whether that order is valid or not. It has the presumption of validity, and the bank can be declared in contempt for obstructing the course of justice. And so, if there is no money in the bank, then the properties, the furnitures, the office fixtures, the vehicles can be attached and sold in public auction, and the proceeds of the sale shall be paid to the workers. So, the only thing that can stop the writ is an appeal that is timely filed with cash or surety bond. Now, the fourth paragraph contains a penal sanction. Any person who obstructs the inspector or who will delay the compliance with the order, any dilatory tactic will be penalized, and the penalty is found in Book 7 of the Labor Code on the penal provisions. There is both imprisonment as well as fine. Now, can the regional trial court issue an injunction or a temporary restraining order directing the DOLE to stop the enforcement of his compliance order? The answer is no. The answer is no, because all courts, inferior courts, that means only the Supreme Court, only the Supreme Court can stop. But inferior courts, even the Court of Appeals, cannot issue a TRO or an injunction order against the enforcement of the regional director or the DOLE's order. Can you imagine how strong is the power of the Secretary of Labor? Not even the court can stop. On the other hand, if the inspector commits corruption, demanding money, or illegal exaction or coercion, he can be subject to summary dismissal if there is ample evidence, even substantial evidence, that quantum of proof which a reasonable mind will accept to support a logical conclusion is enough to cause the summary dismissal of any inspector or any official that is found guilty of abuse of authority or violation of the Anti-Graft and Corrupt Practices Act, subject to summary dismissal without prejudice to the criminal aspect of the offense. So, the last portion is the requirement of records. You know, how can you manage a company without records? You cannot say that you do not have a payroll. If the inspector will ask for a payroll, you have to bring out the payroll. Even the logbook. There is a logbook that is required for occupational safety and health, where all entries about sickness, sick leave, work accidents, even death must be recorded in the logbook. Because when the inspector comes and we look for the logbook, the failure to present the logbook is one separate violation. That is a violation, and that can be subject also to another administrative penalty. So, going to Article 129, the one that we discussed earlier. This is different from 128 because in 128, it is the government going into the establishment. In 129, it is the complainant going to the government, to the regional office. Well, regional office number 7 covers Siquijor and Negros Oriental, including Bohol. So if you are from Siquijor or from Dumaguete, you do not have to go to Cebu City to file a complaint, because there is a district office in Dumaguete. There is a district office in Tagbilaran. So there is also a director, a provincial director, a director 2, that is the rank. For every province, there is a unit. In other words, labor is also decentralized. So the filing of a complaint, any sum of money for non-payment of overtime pay, non-payment of night differential, service incentive leave encashment, as long as it does not exceed 5,000 pesos. I think this amount should be increased because 5,000 pesos in 1974 is already equivalent to $2,500, because at that time in the 1970s, $1 is only 2 pesos. So if you think of 5,000 pesos, that is $2,500 at that time. So now, what is the value of $2,500? That should be the amount to be covered today, but there is no amendment, no? Just like the revised penal code before, the penalty is only 200 pesos, but now it is increased. So there must be a corresponding increase in the amount here. So the regional director or his hearing officer shall decide a complaint within 30 calendar days from the time of filing, not from the time of submitting the case for decision. So there is a sense of urgency. The question is the Dole really complying with this, because of so much volume of cases filed? Can they really perform this duty? Because the wording of the law is shall, it is mandatory, and the regional director can be disciplined. If you are a worker or you have a relative who is a worker and he files a case and the case is not decided within 30 calendar days, you can file an administrative complaint against the director or the hearing officer. Although, you know, the regional director is my friend, but here there is no friend. The law is very clear. Shall decide, and any amount paid, no, shall be held in a special deposit and shall be paid to the employees concerned. Should not be paid to the lawyers. It should be paid to the employees. Because there are many lawyers who are committing violation of legal ethics, withholding the amount that is due to the workers. Here it is very clear that the regional director should pay directly to the employee. Directly. No intermediary, no fixer. It should be directly to the employee. Any sum of money that has not been distributed because the worker could not be located within a period of 3 years. 3 years has lapsed and the workers could not be located. This should be put in a special fund. And this will be audited, by the way, by COA. This cannot be used for other purposes. Now, the decision of the regional director, this is very strange, huh? The decision here under 129 is not appealable to the Secretary of Labor. It is appealable to the NLRC. And the period is only 5 days. Can you imagine 5 days? Calendar days. So if you are a lawyer, you have to work on Sundays and Saturdays. If the decision is served on Friday afternoon, you lose already Saturday and Sunday. And if Monday is a holiday, but you have to comply, no, because period is very important. Now, legal interests are recoverable. The decision of the Supreme Court in Bank, in the case of Dario Nakar versus Gallery Frames, penned by no less than Justice Diosdado Peralta, who is now the Chief Justice, who is, by the way, my neighbor here in BF Homes. The two Chief Justices are my neighbor, Justice Diosdado Peralta and Justice Lucas Bersamin. The interest here is 6% per annum from the time of finality of judgment up to the actual payment. So, any delay, kasi may mga employer, mga abogado mahilig mag-delay, mag-file pa ng motion to quash the writ. Marami pa mga gagawin yung mga abogado. The longer they will delay the execution, the higher would be the interest that could be collected. That is a forbearance of the money. The money belongs to the worker, and it is not delivered immediately. It will bear interest. Now, the third article is about the jurisdiction of the labor arbiter, and this is compared to 128. If I were the bar examiner, I will ask you to distinguish what is the difference between 128, 129, and 224, or among, no? These are my distinction. Pinaghirapan ko itong distinction na ito, ha. Can you see this? Attorney, can you see this? Wala naman. Tao? Ikaw, Mr. Carion, nakita mo ito?
Kita, attorney.
Pwede na niyang kuha ang picture. Pero pag meron kayong kopya doon sa reviewer ko, kuha pag usa ninyong nakakuha itong reviewer. Naara man na sa Santiago.
Nanay ni order of online attorney.
Nana.
Mas-late na ko. Nag-online siya of order.
Sige. Ito kasi importante ito kasi itong ating chairman ngayon mahilig sa distinction. Mahilig yan sa distinction at tandaan nyo yan. So this is a distinction between 128 and 129. Ang unang tanong, what kind of power is granted by law? Answer. Under 128, it is a visitorial power. 129 is an adjudicatory power. So yung visitorial is purely administrative. Adjudicatory is quasi-judicial. Do you understand that, gentlemen? Nakuha ba na ninyo, Mr. Carion?
Yes, USEC.
Ito, number 2. Is there a limit? Sa Article 128, wala nang limit. Sa 129, 5,000 rin ang limit. So, 128 is a stronger power compared to 129. Because even if it will reach 100 million pesos, and that is the regional director may not be a lawyer. In fact, our regional director in Region 7, I think, is not a lawyer. The assistant, there are 2 assistants. One is a lawyer, the other is not. But because if there are intricate questions of law, no, which are not discoverable in the ordinary course of inspection, it may require the expertise of a lawyer. For instance, to interpret Article 106 on the issue of legitimate contracting or labor-only contracting. No? Kasi it can be also subject of inspection. Okay, number 3. To whom is the power granted? 128 is granted to the Secretary of Labor or his duly authorized representative. This is called Delegation of Power. Alam naman ninyo sa administrative law, potesta, delegata, non delegare potest. So the law itself enumerates, it's not just the Secretary of Labor, but the word is or his duly authorized representative. That includes the inspector. Hindi nga na pangalanan ng regional director diretso from Secretary of Labor to the Labor Regulation Officer. That is my first job in the Department of Labor in 1974. I took the bar. While waiting for the bar, I was hired to become an LRO, Labor Regulation Officer. The author of the Labor Code. And if you compare that to 129, the power is granted directly to the regional director. But 128 is on the Secretary of Labor or his duly authorized representative. Number 4, what are the cause of action? Any fact, condition, or matter. No? Any fact, condition, or matter. Where 129, any matter involving the recovery of wages. So, you know, 129 is limited in scope. Wages only. And the term wages may include benefits because it's a generic term. So sa 129, hindi mo pwedeng isama yung job contracting, labor only contracting. Pero dito sa 128, any fact, condition, or matter, 2 kinds of inspection. Routine inspection without a complaint and complaint inspection. When there is, kahit anonymous lang somebody make an anonymous call to the office of the regional director, sabihin, sir, can you inspect a company by the name of XYZ located in Basak, Mambaling? It is a spa and massage clinic, and that this is the name. The receiver of the call does not require that to identify the caller. Just give the address, number, and we will go and inspect. See? There's no need for a complaint. But if that call itself is a complaint, that is considered a complaint. Now, Article 129 will never happen if there is no complaint. 128 may happen even without complaint. Such triggering act, triggering yan hindi yan trigging. where should this official act be undertaken? Where inspection is done in the company premises, but 129 is always done in the office. You cannot do a hearing of money claims in the company premises. Well, when I was a labor arbiter, and that is different because that is Article 217, now 224. I was assigned a case involving an hacienda in Giholngan, Negros Oriental. And the complainants, 300 hacienda workers. To require these 300 workers to go to Cebu City for a hearing is impossible because they have no money. So I was the one who went there together with the stenographer. We conducted a hearing under the mango tree. That is allowed by law for the labor arbiter. But here, in Article 129, it's not a labor arbiter, it's a regional director. This is purely administrative, quasi-judicial. While the labor arbiter really is just like an RTC judge. You can conduct a hearing in the scene of the crime or in the situs of the cause of action. Number 7, is there a deadline set forth by law? Under 128, there is no deadline. But in 129, they have to resolve the complaint within 30 calendar days from the date of filing. Can you imagine that? Did you take picture? Kayo, did you take picture of this?
Yes, yes.
Oh. Number 8, is there an effect in the presence or absence of employer-employer relationship? Well, under the rules implementing Article 128, if on the face it could be ascertained that employer-employer no longer exists, the case whether it is accompanied by illegal dismissal, no, shall be endorsed by the regional director to the NLRC. Well, that is if there is a complaint. But if there is no complaint, there is nothing to endorse, no? Because this is pure inspection. The next page. How is the case resolved? Under 128, an order issued. Yan ang compliance order. But in 129, it should be a decision. A decision because there is a complaint. Decision should be issued within 30 calendar days. No? And may the Dole Secretary order the stoppage of work? Yes, under 128. In 129, no. Where should appeal be filed? In 128, it is the office of the Secretary within 10 calendar days. In 129, it is NLRC within 5 calendar days. What are the grounds for the appeal? I have already discussed that earlier. What are the requirements for the appeal? Well, I have discussed the cash bond. In 129, there is no requirement of a cash bond. The law is silent because it's only 5,000 pesos. Kailangan ba yung cash ban? 5,000 pesos. Within what time should the appeal be resolved? Article 128 is silent. 129 gives 10 days. The NLRC has only 10 calendar days. I don't think they can do this. They are given 10 calendar days from the time of the submission of the last pleading. But anyway, that is the law. When does the decision becomes final and executory? In 128, it is 10 calendar days from receipt of the decision. Also in 129. Who issues the writ? In 128, it is the Secretary of Labor or the Regional Director. Well, in 129, it should be the labor arbiter because this is NLRC. Although the law is silent. So, with this distinction, you can already see the difference between 128 and 129. Let us now look at 129 versus the labor arbiter. What kind of power is granted? Adjudicatory in 129, quasi-judicial in 224. Is there a limit? Yes, in 129. Yes and no under 224. Why no? There is no limit downward. There is no limit upward, but they cannot accept money claims lower than 5,000. Kasi ang 5,000 pag ipinail mo sa labor arbiter, sabihin na wala kami dyan, doon yan sa regional office. If there is no claim for reinstatement, if it is not accompanied with another cause of action which is illegal dismissal. Kahit 5 piso lang ang money claim, basta merong illegal dismissal, labor arbiter na talaga yun. No? So, upon whom is this power granted? Regional director and then labor arbiter. You know, my advantage is that I was a labor arbiter and I was also a regional director and I was undersecretary. Alam kong kaibahan dito. What are the cause of action specific matter assigned by law? I discussed that. Yung 224, unfair labor practice, termination dispute, and that is enumerated in Article 224, including claims of migrant workers. By virtue of the Republic Act 8042, which is the migrant workers, the Magna Carta for migrant workers. So this is just repetition and repetition. Now let us look at 128, which is subject matter tonight, versus 224. 128 is visitorial power, 224 is quasi-judicial power. There is no limit in 128, but in 224 there is no limit upward, but there is a limit downward. The Secretary of Labor is vested under 128. The labor arbiter is vested under 224. You know, to become a labor arbiter, you must be a member of the bar. But to become a regional director or even secretary of labor, you need not be a lawyer. We have had a lot of secretaries of labor who were not lawyers. But mostly are lawyers, including Secretary Bello and the predecessor, Secretary Baldos, Laguisma, Drilon, mga lawyer yan. Pero yung mga hindi lawyer, sila ni Confessor, Santo Tomas, Roque. What kind of power is granted by law? Visitorial power, quasi-judicial. So, again, this is a repetition. I don't want to bore you with repetition. Now, let us look at this. Can you see this on the screen? Mr. Carrion, ikaw lang ang maalala ko dyan.
Kita ko USEC.
Okay. Kuha yung nag-picture kay very important ni ba? Kamo nga naminaw. You take picture because this is very important. If you look at the provision of magumpisa ta dito sa kaliwa, no? Interpretation and implementation of CBA. You know, the provision of the Constitution expresses preference for voluntary modes of dispute settlement. So, if a company is unionized, there is a grievance machinery because there is a collective bargaining agreement. Lahat ng mga kumpanya nga may union, doon na sila collective bargaining agreement, and it is a required provision of the collective bargaining agreement to have a grievance machinery. So, if there is any dispute concerning interpretation of the collective bargaining agreement, you cannot bring that to the labor arbiter. It should be dismissed. The jurisdiction is exclusive to the grievance machinery. Now, even if there is no union, if the question is about company policy, about example, a company revise its policy, increasing the penalty for a certain violation, you cannot bring that to the labor arbiter or to the regional director. You should bring it to the grievance machinery. And then the grievance machinery is given only 7 calendar days. If the grievance machinery is not able to resolve, that should be brought to voluntary arbitrator. It is compulsory to bring it to voluntary arbitrator, not to the NLRC. You know, I am a voluntary arbitrator now. Our national president of the Association of Voluntary Arbitrators is the Vice Mayor of Cebu, Michael Rama, who was my student here in UB. And I am now the Executive Vice President. Nagpabayos lang ko sa aking estudyante kay sikat man siya. So, we are also handling cases right now. And these cases involves implementation of CBA, enforcement of policy, and may pangatlo, any other case any other case if the parties will agree to submit to voluntary arbitration. Even those cases that should be brought to the labor arbiter can be brought to the voluntary arbitrator, and that is one very rare instance where the parties are allowed to choose jurisdiction. Diba? In your remedial law, you learn that jurisdiction is vested by law. It is not chosen by the parties. But an exception is here in voluntary arbitration. The parties can choose to bring any case as long as the two parties will agree. They can bring it to voluntary arbitration. So if you are asked, what are the jurisdiction of the voluntary arbitrators or voluntary arbitration? Number one, interpretation and implementation of the CBA which was unresolved by the grievance machinery within 7 calendar days. And number two, enforcement, any question about enforcement and implementation of company rules and regulations on discipline which has remained unresolved by the grievance machinery within 7 calendar days. And number three, any other labor dispute, any other labor or industrial dispute by agreement of the parties can be submitted to voluntary arbitration. So, after the voluntary arbitrator decide the case, it can be brought to the Court of Appeals, not by Rule 65, but by Rule 43. From the Court of Appeals to the Supreme Court, Rule 45. So, remember that. The Chairman Marvick Lunin is very fun about jurisdiction, about reglementary period, about grounds for appeal. You should remember that. Now, let us go to the NLRC. Article 129, Regional Director. Money claims not exceeding 5,000. Appeal to the NLRC. Appeal to the NLRC within 5 calendar days. An NLRC to resolve the dispute or the appeal within 10 calendar days from the filing of the last pleading. And from the NLRC, Rule 65 to the Court of Appeals for grave abuse of discretion. 60 days. Then from Court of Appeals to the Supreme Court, Rule 45. Now, Article 217, which is now 224. This is money claims exceeding 5,000, termination dispute, unfair labor practice, moral damages, claims filed by migrant workers under Republic Act 8042 as amended by 10022. The labor arbiter is not like the regional director who is limited, who has a mandate to decide the case within 30 calendar days. But the labor arbiter, once he decides, the appeal to the NLRC is 10 calendar days, while the regional director is only 5 calendar days. And under Article 218, which is now Article 225, the NLRC can issue injunction, not the labor arbiter, but the NLRC can issue injunction on cases that involves employer-employee relationship. SSS and JSIS appealable to the employees' compensation. Then the regional director in Article 128, as we have discussed tonight, appeal to the Secretary of Labor within 10 calendar days. The mid-arbiter pertains only to intra-union or inter-union dispute. Either appeal to the Secretary of Labor or the Bureau of Labor Relations. Strike cases are those that are assumed subject to assumption by the Secretary of Labor when there is a dispute that is causing or likely to cause a strike in an industry that is indispensable to national interest. So this chart therefore is very important. Maybe I am the only professor who prepared a chart like this to make it easy for the student to look at in one page practically the entire totality of jurisdiction, and this is very important to you. Well, these are the matters that are subject to the inspection. Salary, cost of living allowance, premium pay for rest day. These are all labor standards. And we will discuss this or we have already discussed some of this in our previous session. Maybe I will give you an orientation about the organization of the Department of Labor. The Department of Labor is composed of many staff agency and line agency. The line agencies are the one on top, Bureau of Local Employment. BLE is local employment. What is the function of this office? This office is in charge of promoting jobs, and the director is Assistant Secretary Nikki Tutay, who is from Dumaguete. And this is the one in charge of job fairs, yung mga local employment matters to. The next one is Bureau of Labor Relations. This is the registrar of all unions in the Philippines. When it comes to intra-union and inter-union disputes, the Bureau of Labor Relations are in charge of registering federations, national unions, anything about unionism, Bureau of Labor Relations. BWC is the Bureau of Working Conditions. This is in charge, if BLR is in charge of Book 5, BWC is in charge of Book 3 and Book 4. Bureau of Working Conditions is in charge of wages, benefits, and occupational safety and health. Bureau of Workers with Special Concerns, itong BWSC. This pertains to women, minors, PWD, yung mga sugar cane, yung mga there is a special law for sugar workers and they are implementing a sugar social amelioration fund, because some workers in the sugar industry do not have jobs on if it is not milling season, so they devise a system to augment the source of livelihood for the sugarcane workers. So we need a worker like a bureau of workers with special concern. ILAB is International Labor Affairs Bureau. This is the one that is coordinating all the labor attaches all over the world. The labor attache, if you are a labor attache in a specific country, you are practically equal to the ambassador. No? Our labor attache in Malaysia now is from Cebu. It's Johnson Cañete, who used to be regional director, and he was the one who replaced me, and he covers the entire Malaysia, which include 2 islands. The main island attached to Thailand, and the other is the island of Borneo. The island of Borneo is composed of 3 countries. The biggest slice belongs to Indonesia, then the very small Brunei, and the northern part, which is Sabah and Sarawak. And Sabah and Sarawak are 2 states affiliated with the Federation of Malaysia. So that is also covered by Cañete. So when you are a labor attache, you are in charge from hiring to cremating. No? Hanggang na-cremate na yung mga OFW, ikaw pa rin mag-alaga. And so I was assigned to that for 9 years in 3 countries. So ILAB is the bureau. Itong NRCO is the National Reintegration Council for OFW. This is the agency in government that will take care of returning OFWs, because OWA will take care when they are still abroad, but once they come home and they are no longer employed, how to bring the migrant workers back. The agreement must be registered sa region yan, but the region will forward all the registration to the Bureau of Labor Relations. Nakuha mo na yan, Mr. Karyun?
Nakuha na. Klaro na na po. Medyo naglibog daw sa akin aming PLR, sa jurisdiction sa PLR yun.
At least pag nalibog ka, maayon na, that is a good sign. Because you are thinking, kana mga malibog, ambot lang ka, o naklaro na ba nila, o wabagin sila, ikuanan na. No? Ewa man ko malibog, sir. Saan mo pagkalibog, o wagin yung kakahibalo. May na kanang nalibog, muna na naibawaan, pero na-confuse lang siya, kaya daghang kaig mga input, no, sa contradictory.